Okay. So I'm going to get a little wonky here, a little technical. What we're talking about in this presentation is protecting your intellectual property in this industry. So for those of you who are either establishing a brand or building a brand or trying to scale a brand, then this presentation will be especially important for you. You guys got my disclaimer from this morning. You know who this ugly mug is. Um, but let's get to the presentation. So, intellectual property, right? As this industry grows and professionalizes, we need to think about how we go about protecting our intellectual property. And this is a challenging space to protect your intellectual property in, because some of the traditional methods that we would use in any other industry are not going to be available to us, right? So let's take a look at the federal landscape. I mean, this is not new information to anybody, but cannabis is still federally illegal. That includes growing, processing, selling, knowingly renting, managing, or using property for the manufacture or distribution of cannabis, selling or offering to sell drug paraphernalia. So, not even the cannabis itself, but equipment or products or materials of any kind that are designed to be used for the manufacture of cannabis or the production of cannabis. And then the catch all provision, deriving profits or proceeds from any violation of the Controlled Substances Act. So, as you can see, the CSA is what governs cannabis in this country right now. The reason why this is important is because many of the tools that we would use in other industries to protect our IP are limited to what's federally legal because they are federal nationwide tools. All right. So let's go over a brief glossary. THC is the abundant cannabinoid in cannabis. It's responsible for cannabis psychoactive effects, or the high. And then CBD is one of the many other cannabinoids found in cannabis, and that has recently gained support for its medical use and treatment, given that it helps with pain, inflammation, and anxiety without the psychoactive effects of THC. All right. But these are the compounds that are found in cannabis. So I bring that up just to help you understand why this is still federally illegal and what the CSA's impact has on these very same intellectual property protection mechanisms, right? So just to give you an overview of what those are, first we have trademarks. This is a biggie, right? A trademark is a word, a name, a symbol, or a device that is used in trade. It is associated with a good or a service. So think about logos. For example, the Nike swoosh is their logo. It's instantly recognizable. Nobody can see it and not think to themselves Nike, right? That swoosh is trademarked and protected. No one else can use that symbol, right? A patent is another example, and this protects inventions and excludes others from making, using, or selling an invention without the permission of the inventor. The limitation on patents is that they're only good for a limited amount of time, right? Copyright. Copyrights protect original works of authorship. Now, that could be literary, it could be dramatic, it could be musical, it could be artistic, or other certain intellectual works. And it covers those works whether they are published or unpublished. And then finally, trade secrets. Trade secrets are information that is sufficiently held secret so that you can derive economic value from it, and it's subject to efforts to maintain its secrecy and confidentiality. What I mean by that is if something's a secret, but you don't take any steps to protect that secret, it will no longer be deemed a secret. So we'll get into the mechanics of that. But these are the 4 tools, so to speak, that we would use to protect intellectual property. So let's get into trademarks. Trademarks traditionally are registered federally with the United States Patent and Trademark Office. You can apply for them in 2 different ways. You can do a use in commerce application, which means that this mark is already being used, or you can do an intent to use application, right? The problem is that the USPTO will only offer trademarks on goods and services that are lawful under federal law. So you can already see where this is a conflict in cannabis, right? Trademarks are also protected by state and common law. The USPTO, the federal trademark, is nationwide protection. State trademarks are statewide protection. And common law trademarks really only protect you in regions where you're already doing business. I bring these 3 up, but I want to strongly emphasize state trademarks. Cannabis is legal in the state of California. The state does not have the same hangups around issuing trademarks that the federal government has. If you have a brand and you are licensed here in California and you are running into issues getting federal trademarks, or you don't even want to commit your resources to pursuing that, I would strongly advise you to look at a state trademark. Unless you're a multi-state operator, and I don't believe we have any of those in the room today, a statewide trademark is probably enough. Your local permit here and the license that you get issued by the DCC from the state is only good within the state of California anyway. So unless you have a real strategy to start expanding outside of California, you may want to take a look at obtaining a state trademark to protect your brand. In California, state trademarks are registered through the Secretary of State. And hopefully we'll get these presentations shared with you, because there are links in the presentations that can take you directly to where you need to go. But that's it on the screen. So you can apply there for your state level trademark. We're going to continue to talk about the USPTO a little bit, because their policies around cannabis are in flux right now. They are actually going through training at the USPTO office on how they could potentially issue trademarks in cannabis, and they are developing rules around issuing trademarks in cannabis. So it's not impossible that here soon we may have a change in position at the federal level. But as of right now, today, chances are you will not be issued a federal trademark. But if you're interested, take a look at the link for the USPTO's examination guide on marks. There may be a possibility, if you're willing to invest in it, to get a federal level trademark. But again, I don't know that it's necessary unless you really have a strategy to expand outside of California. The state of California is probably sufficient. Additional types of trademarks. This is for the cultivators in the room. If you're plant touching, right, there may be other trademarks available for you, right? So let's talk about what you might trademark. If you have a logo or a design that you might want to trademark and use in cannabis, Could you trademark it on t-shirts? Could you trademark it on backpacks, apparel, and then use that same mark in cannabis? There may be some alternative strategies that don't perfectly match getting a trademark on your cannabis products, but could you approximate it by getting something else that is acceptable trademarked? That might be one strategy. And in this case that I mentioned here, INRI JJ 206 LLC, the U.S. Trademark Trial and Appeal Board denied a mark for cannabis vaporizers. What this company went on and did was take the same mark that they were trying to trademark with cannabis vaporizers, and they started applying it to carry cases and backpacks and apparel. And so the mark itself was protected, right, based on the usage on these other items. But they applied that same mark to their vaporizers anyway. And so if somebody tried to use a similar mark on a competing vaporizer, you could still make the argument that that's infringing because it may cause confusion between the competitor's vaporizer and your other non-cannabis goods that you were selling that got marked. Whenever I bring this up, some people ask, well, aren't they infringing on First Amendment rights if I can't trademark my cannabis logo? And in short, no, they're not going to consider that to be an infringement. Despite recent Supreme Court cases, and there's two on here, Brunetti and Tam, where they said that the USPTO cannot prohibit operators from getting marks because their product was deemed immoral or scandalous or disparaging or unconstitutional. So some people have suggested that really cannabis is illegal because people thought it was immoral. And so if you can no longer block trademarks for immorality, shouldn't I be able to get a trademark on my cannabis product? Sounds good. But again, as of today, the USPTO is not issuing those marks. So even if they were to allow some of these marks to be approved, there would still be additional challenges in registration. One, clearance searching. There is no database now of cannabis marks that have been registered for them to search to see if your mark is indeed unique. And let me tell you, lack of uniqueness and lack of distinction is a real problem here in cannabis. What you see on here is a word cloud. And this word cloud represents cannabis business names and brand names. And what I want you to take from this picture is the closer those dots are together, the similar the names are. Everybody in this industry is Canna something, or green this, emerald that. I mean, there's no creativity in this industry at all. Right? And part of the problem in protecting your IP is that if you did want to pursue a trademark, your trademark needs to be unique. It needs to be distinctive. It's hard to make that argument when everybody's name and brand sounds similar. So even if they were issuing these marks today, it may still be very difficult to get them through and get them registered. So let's talk about patents real quick. Like trademarks, patents are registered and maintained federally. But unlike trademarks, they do not require a lawful federal use. So if you come up with a unique invention here in the cannabis industry, it is fully patentable. You can get a patent on it, right? There is no state equivalent of this. This has to be done at the federal level, but for whatever reason, the patent office does not have the same hangups on lawful use that the trademark office has. Patents must be new, they must be non-obvious, and they must be useful. If your idea is not new, you won't get a patent. If your use is not obvious, or excuse me, if it is obvious, you may not be able to get a patent. And if it's not useful, you may not be able to get a patent. But that's not a high bar to overcome if you come up with something unique and new that is useful for this industry. So there are plenty of patents that have been issued in this industry. Look at all the equipment manufacturers producing tools and equipment for this industry. All of that stuff is patentable. So let's talk about the different types of patents. There's a utility patent. This is a patent that's largely based on some new use, right? There are design patents for unique designs. What I commonly get asked about, and again, this is from the cultivators potentially in the room, is what about plant patents? Can I patent my seeds? Can I patent my genetics? Possibly. Plant patents have a very narrow window for you to get your qualification in. It only protects asexual reproductions of any distinct and new variety of plant. Let me re-emphasize, asexual reproduction of distinct and new varieties of plant. It does not apply if the plant was tuber propagated. It does not apply if the plant is found in an uncultivated state. And the other limitation is that it's only good to protect you against a cultivator growing the same cultivar from a clone. Okay. They do have this Plant Variety Protection Act that will protect certain plant varieties. But again, these have less protections in place than your typical utility patents or design patents. So what is the protection we're talking about with patents? A design patent protects your invention for 15 years from the date the application is filed. All other patents run for 20 years from the date the application is filed. The other caveat is that patents require public disclosure. What you are telling the government is, I am willing to share my knowledge and my idea with the public in exchange for a limited amount of protection for a limited amount of time. Copyrights. This is important for those of you who cannot obtain a trademark for whatever reason. Copyrights are an alternative. Okay? To obtain copyright protection, the content must be original to the author. It must be something that you came up with. It must have a modicum of creativity. And it must be fixed in a tangible medium. The protection it provides is it limits anyone's right to reproduce, display, distribute, perform, or to create derivative works from your copyrighted material. From a cannabis perspective, federal copyright protection is available to protect most business creations. So if you had innovative advertising that you might want to engage in, whether that's on social media or email campaigns or on your website, chances are all of that is copyrightable. If you have training materials, think SOPs for my manufacturers and my cultivators. That's copyrightable material. If you have certain descriptions of your products or compelling photographs of your products, that's all copyrightable material. You may not be able to get a trademark for some of those, but you can have protection on those images, on those words, so that someone else can adopt them for their business use. If you develop a unique packaging design or how the packaging is configured for your products, that's copyrightable. And again, as an alternative to trademarks, if you develop a logo, I'm sure everybody in here has the coolest, sexiest logo I've ever seen, that is also copyrightable material. Again, there is no federal prohibition, or virtually none, on what types of works are eligible for copyright, right? Including cannabis-related works. Now, federal registration is not required for the protection, the same way registration may be required for trademark protection or registration is required for patent protection. There is no registration requirement for copyright protection. However, if you want to file a claim in federal court for copyright infringement, then your copyright does need to be registered. It's not required, but it may limit your avenues to seek relief if you don't register your copyright. So let's talk about the duration of copyright protection. It's going to sound like a long time, but considering that trademark protection could be forever, there are some limitations with copyrights as an alternative. So works created by an individual are protected for the life of the author plus 70 years. Okay? And works created anonymously or works created for hire are protected for 95 years from the date of publication or 120 years from the date the material was created. So again, that sounds like a long time, but there are businesses in this country that are over 100 years old. And trademark protection could conceivably be forever. So although I'm suggesting that copyright may be an alternative if you have trouble securing a trademark, in most cases, getting a trademark is better, right? So trade secrets. I want to spend time emphasizing trade secrets because this is how most intellectual property is protected in the cannabis industry. And there's no mystery around trade secrets. It's just you keep it secret. Think the recipe for Coca-Cola. It's not patented. It's not a registered copyright. They keep it trade secret because we know patents expire. We know copyrights protection goes away at some point. Trade secret is the only way they could keep something as critical as their Coca-Cola recipe protected into perpetuity. If you're a manufacturer and you have a proprietary product that you've developed that you think is going to take off, and you have a unique recipe about how you go about producing that product, trade secrets are likely what you're going to rely upon. Okay? And those secrets are protectable and can last indefinitely as long as they remain secret. So I know some of you are thinking, well, Zach, didn't Coca-Cola have to share their recipe with their employees so it could be produced? And the answer is yes. Right? So what do we do to protect that information that in some cases we may have to share? Well, it's done contractually. Right? So as part of those employees' agreements to be hired, or as part of their handbook, they're agreeing to an obligation to keep those things secret. And there could be significant civil and financial consequences for them if they don't. Okay? So, what could be the subject of a trade secret? Could be ingredients, recipes, business plans, vendor lists, customer lists, processes. All these things are valuable in the context of trade. And again, these are protected under state law here in California as well as under federal law, but only to the extent that you protect them. So you need to have those confidentiality agreements in place. You need to not only have those in place, but you need to be ready to enforce them. If somebody infringes on your trade secret, if you have an employee that quits your company and decides they want to take your secret elsewhere, it's not enough that you say, this employee did me wrong, and I'm going to try to enforce this confidentiality provision against them. You need to be more aggressive than that. You need to go after that new company. You need to try to get injunctions. You need to take every step reasonably possible to prevent that secret from getting out once you know that it's been exposed. It's not a requirement that you just keep it secret. You have to maintain its secrecy, and you have to be ready, willing, and able to defend that secrecy. Right? So what do we use? Written non-disclosure agreements. Non-compete agreements where they're lawful for anyone who has access to the information. You need to store the information securely. If you have your recipe book just lying on the table in your facility, that's not secured storage. You are not taking the steps necessary to get trade secret protection. If the information is digital, is it on a secured device? Is it in a secured cloud? If it's not, chances are you won't be afforded trade secret protection. If there are physical files, do we have them locked in a room or locked in a file cabinet? Is that area of my facility restricted access? And if so, then we've probably met our burden. So some of the cannabis concerns with trade secrets, right? Any public disclosure of a trade secret will waive its protection. So I bring this up because as for those of you who have already applied for state licensure and even state or local permitting, we are being asked to share a lot of information about our business. The state in particular wants you to provide SOPs, standard operating procedures, as a part of your application. Anything you submit as part of the application process becomes public record. So if you are sharing proprietary information in that application, you are not going to get trade secret protection. You need to be careful about that. And where does litigation occur? Litigation in this area occurs when employees or groups of employees leave a company, or if a competitor is alleged to have taken a company's secrets and created their own products with it. You often see companies release similar products, and then there's an allegation that they stole that idea or stole some information from their competitor. This is where the fights come in. So avoid that. Make sure you have agreements in place. Make sure your employees are trained up on their obligations, and then take the steps necessary to protect your information. Trade secrets require more effort to protect their information than any other type of IP protection. But it is the most common form of IP protection in this industry. So get comfortable with the idea that some of your IP will have to be protected as a trade secret, and then take the steps necessary to ensure that protection. Thank you. Told you this one would go faster. And then if you have any additional questions, you can contact the DCR at the emails that you see up on the screen. And I would once again just strongly advise everybody in this room to take advantage of the resources the DCR is making available to you. All these things go underutilized. People aren't sure about how to access them.